Hello, and welcome to another event in Clause 40 Foundation's series of conversations on emerging scholarship in criminal law and policy. I'm Carolyn Iodice, Senior Counsel for Clause 40 Foundation. Clause 40 exists to bring broader awareness to the erosion of due process rights in the criminal legal system. And this event is a conversation about the alarming use of junk science against people who've been criminally accused. Junk science refers to forensic techniques that have proliferated in American courtrooms despite having little to no scientific basis. From bite mark comparisons to arson indicators to microscopic hair analysis, these techniques have been used in criminal trials without being subject to adequate scientific scrutiny. And as a result, innocent people have been convicted, sent to prison, and even sentenced to death. Today, I'm interviewing Chris Fabricant, a leading figure in the movement working against the use of invalid forensic science. Chris is the Director of Strategic Litigation at the Innocence Project, where he fights junk science and other sources of wrongful convictions through pioneering litigation and advocacy, which are detailed in his new book, Junk Science and the American Criminal Justice System. We're going to delve into how junk science made its way into the courtroom, what advocates for reform are doing to try to address it, and what its proliferation suggests about the criminal legal system's ability to deliver actual justice and secure Americans' due process rights. Thank you for joining us for this important conversation, and thank you, Chris, for being here.
Thank you for the invitation.
I want to start off talking about one of the cases that you detail at length in your book, because I think it really demonstrates for folks how egregious these junk science cases can really get. So can you walk us through what happened in the case of Eddie Lee Howard? How was junk science used to investigate and then ultimately to convict him?
Eddie Lee Howard was convicted of the rape and murder and attempted arson of Georgia Kemp's house and the murder of Georgia Kemp. Georgia Kemp was an elderly white woman living in Columbus, Mississippi in the early 90s. Eddie Lee Howard was an indigent black man who was living in the same neighborhood around that time. On a Sunday afternoon, late Sunday afternoon, a neighbor saw smoke billowing from Miss Kemp's house and called the fire department. The fire department arrived on the scene and found Miss Kemp in a state of undress, and she'd been stabbed multiple times. There was a butcher knife that was near her body that appeared to have been the murder weapon. Her phone line had been cut, and that was really the only evidence that they had. There was no fingerprint, there were no eyewitnesses, there was no real suspect. Miss Kemp did not have any known enemies. There did not appear to have been a burglary. She had very little of value in her home. And so she was taken to a morgue in Pearl, Mississippi, and was autopsied by the notorious forensic pathologist Stephen Hain. Stephen Hain documented this body very thoroughly, Miss Kemp's body, and took photographs of both the front and the back and the sides of her corpse before conducting this very thorough autopsy in which all of her internal organs were removed. Her brain was removed from the cranial cavity. She was buried unembalmed for the next week. Meanwhile, police were investigating the crime and could not find any eyewitnesses or any particular suspects. And essentially what they did was a dragnet of black men in the neighborhood. And Eddie Lee Howard was one of these people. He was picked up by the Columbus police. He was interrogated very thoroughly and made some vaguely incriminating statements, but also had said that the crime had been committed by some, a pack of other people. And it was apparent just from any kind of objective reading of what he had said that he had no information for the police. And, but yet they believed he was good for it. And what they decided, and this is an important point about Mr. Howard's case in particular, is that they decided that they were going to get a mold of his teeth even before they had examined the body. And what they decided to do is when they alighted upon Mr. Howard as a suspect was disinter the remains of Georgia Kemp and bring
After a few days, right?
After a few days of being buried underground, unembalmed, after a very thorough autopsy with no thought that somehow this was going to be an open casket or anything like that. And so they decided to disinter Ms. Kemp's remains, and they decided to hire the notorious bite mark expert, Dr. Michael West. Michael West, even by this time, had been largely discredited as a forensic odontologist, as the forensic dentists like to call themselves. There's no difference between an odontologist and a dentist, for the record, but
one sounds more fancy.
Yeah, or sciencey, right?
Mm-hmm.
You know, so there's forensic odontology. And he brought, 4 days after the burial, was brought up from Hattiesburg, Mississippi, where he had been using what he called the West phenomenon, and that's where he used ultraviolet lights to see injuries reportedly beneath the skin that other people could not see. But normally you would have some sort of injury on the surface of the skin to indicate that it had been healing and that there was something underneath that would suggest that there was some injury. But there were no such injuries on Miss Kemp's body at all. And nonetheless, they brought these remains to the morgue, and Dr. West examined these remains for about 4 or 5 hours, beginning around 1 o'clock in the morning for some reason, and discovered 3 alleged bite marks on Miss Kemp's body. One on her breast, one on the back of her arm, and one on her neck. And what was astonishing about the ability to identify these was that Miss Kemp's entire chest cavity had been removed during autopsy, and her head had been, severed as a result of the autopsy. And the area where they claimed to have found a bite mark on her neck had been dissected during the autopsy. So the idea that you would have some probative evidence as a result of this, even, bite marks under any condition are junk science, but under these particular circumstances, were, the worst of the worst as far as this goes. And, probably all the more astonishing was that ended up being the only evidence against Mr. Howard at trial, and he was charged with capital murder. He was allowed to defend himself during his first trial. And during that trial, Dr. West, and this really speaks to the power of any kind of alleged scientific evidence, because it was really the only thing that they needed was Dr. West's credentials, which we should talk a little bit about. But there was no physical evidence. There was no photographs of the alleged bite marks. There was no diagram. There was no showing of this type of evidence. It was simply a naked assurance on the witness stand by Dr. West that he had found these bite marks and matched them to Eddie Lee Howard to the exclusion of everybody else on the planet. So that conviction, where Mr. Howard was defending himself, Mr. Howard tried to put on alibi evidence, but he's not schooled in the law and had a disastrous presentation. There was no effort to mitigate his sentence at the sentencing procedures, and he was sentenced to death. The Mississippi Supreme Court reversed that conviction because he was allowed to defend himself in a capital trial.
Not on anything related to the junk science.
No, not because there was no evidence against him, not because this was a fraud, but because he was allowed to defend himself. And so they went back to trial again. This time he had a lawyer, really essentially a warm body next to him during these proceedings. He did not put on any alibi defense. Did not cross-examine Dr. West on the fact that this entire body had been autopsied before he allegedly discovered these bite marks. And Eddie Lee Howard was sentenced to death a second time. And the Supreme Court affirmed that conviction, even though at that time Dr. West had already been discredited by the wrongful convictions of LeBron Brooks and Kennedy Brewer. So he was known even in the annals of forensic odontology, which is a totally discredited field, or certainly as it relates to bite mark analysis in comparison. He was amongst the worst offenders and had been suspended by the American Board of Forensic Odontology one time, which this is the only suspension that they'd ever leveled, but he was reinstated in time for this trial. And so you see that when you read the transcripts of the trial, you could see the credentials and how important they were, and that he was a board-certified member of the American Board of Forensic Odontology, and he was a member of the American Academy of Forensic Sciences, and he taught at Scotland Yard, and the AFS had sent him to China as an ambassador, and the FBI had funded his research, and so had the ABFO. And those credentials were really as persuasive as anything else, you know, and something I document a lot in the book is just how these were invented entirely, right? They just decided to call themselves the American Board of Forensic Odontology and start handing out, you know, board certification.
So Mr. Howard gets convicted again then in 2000, and that conviction's affirmed. And then he isn't ultimately exonerated until last year. He's released in 2020.
Exactly.
So this is very recent history.
Oh yes, you know, Mr. Howard has, you know, been out for about 1 year, and you know, if you look at the facts of his case and you look at the history of the Mississippi justice system, you know, you can only conclude that this is really the product of structural racism that was facilitated by junk science, right? You know, I mean, and so much of you know, unreliable evidence and the fact that we don't really care about what kind of evidence is used in criminal court is really as much about structural racism and mass incarceration as it is about science, right? It's just that we don't really care what kind of science we use in these cases, even in capital cases. And Eddie Lee Howard's case is really the paradigmatic example.
So hearing his story, I think the first question that comes to mind is how on earth this evidence makes it into court, given that much of the utility of a criminal trial is to try and separate fact from fiction, figure out what happened here. So what is the legal standard for letting in expert evidence, and then how does that actually play out in practice?
So technically, I mean not technically, there are two legal standards in use in the United States today. There's one that's called the Frye Standard. It's from a 1920s DC Circuit Court opinion that actually involved early iteration of a lie detector test. And what that test is essentially that, you know, evidence is admissible, alleged scientific evidence is admissible if the relevant scientific community has generally accepted this. So that standard was really about judges were supposed to defer to the scientific community, and because they're not scientists, that if it's accepted by the relevant community, then it will be admissible evidence, right? And that first case, the Frye case itself, define the relevant community as many different forensic or scientific fields that would be implicated in something that involved a lie detector. In other words, it wasn't the proponents of lie detectors that were considered the relevant scientific community. But what you see in the interpretation over the years, and this is also something I talk about in the book, is that courts were routinely deferring to these niche board certifying entities or people whose livelihoods depended on the continued acceptance of these various forensic techniques, right? So if you ask a person whose living depends on the continued admissibility of this evidence, whether it's generally accepted, your answer is going to be very predictable, right? And so that allowed something like the American Board of Forensic Odontology to become the relevant scientific community. So this was also being used in civil litigation as well, right? So the standards apply to both criminal and civil litigation. And what happened during the 70s and 80s is that we had this, you know, exponential growth of the American legal system on both sides, right? On the civil side, we had an explosion of personal injury litigation and class action litigation related to product liability and toxic tort litigation. And expert witnesses that were used in those cases, they became professional experts, right? That was a cottage industry, rose up where people were not even, that was the only job that they had. And on the criminal side, we had the explosion of the drug war and mass incarceration. And all the more forensics became much more a part of regular criminal prosecutions as the advent in the post-World War II era of the FBI crime lab, which was the progenitor of many of the techniques that I talk about in the book: comparative bullet lead analysis, hair microscopy, and firearms analysis and tool marks, and some of the more traditional forensic techniques. So that was what was going on in the 70s and 80s. But on the civil side, corporate America was getting really, really tired of subjective speculation being used in a lot of litigation, and they were losing a lot of cases by very sympathetic plaintiffs. Some of that was righteous litigation, Ford Pintos are off the streets, as a result of that. But some of it was bogus too, and it was, and so corporate America had had enough. And what they did is they teed up the case called Daubert, and Daubert, and looks as though it should be pronounced Daubert, but people I know who know the Dauberts, that's the way they pronounce their name. And what they wanted was that the courts to have a more rigorous test for the introduction of scientific testimony. And they won. It got to the Supreme Court. The Supreme Court decided for federal courts that it would no longer defer to the relevant scientific community. It would require judges to act as gatekeepers. And what that meant was that they had to apply basic fundamentals of science to a proffer of alleged scientific testimony. So things like error rates and whether or not it's testable and has it been tested, and is it capable of even being tested? Some of the other relevant, and also, they adopted part of the Frye test. It also was a relevant scientific community accepted this as well. But the idea is that it was judges going to be in charge of what was science and what wasn't going to be science, and that they weren't going to define it this narrowly. That became the law of most states in the jurisdiction. Notable exceptions, some of the most populous states in the country still use Frye, including New York and California and Ohio and Pennsylvania, kind of, and Illinois all use Frye still. So in the years that follows after Daubert, there was a study done. And to be clear, and this is also something I write about in the book, is that criminal law didn't really come up at all during the litigation. But it would, of course, apply to both. And about 10 years after Daubert, Peter Neufeld, co-founder of the Innocence Project, conducted an empirical study that demonstrated that while on the civil side, judges became much more willing to exclude unreliable evidence. The numbers went up something like 40% increase in excluded evidence. And on the criminal side, nothing had changed. Literally nothing. And that
they're using the new standard, but it doesn't actually result in more exclusion of junk evidence.
No, despite the advent of forensic DNA, where we knew that these techniques that were being accepted were leading to wrongful convictions. And then you fast forward to 2018, and a study that I conducted with Professor Brandon Garrett from Duke Law School demonstrated that in the next 20 years, nothing had changed. And at that time, we knew that nearly half of all wrongful convictions overturned by the use of DNA involved the misapplication of forensic sciences. So this idea that we care about scientific rigor in the criminal legal system is plainly wrong, right? And this is what I started calling in the book poor people's science, right? Because there can only be one explanation for this, right? Is that on the civil side, we care more about money than we do about life and liberty, and that's particularly true of those who we prosecute in our justice system, which is marginalized communities, poor people, disproportionately poor people of color.
So how widespread is this problem of junk science? Beyond bite marks, what are some of the other techniques, and what kind of criminal cases does it end up getting used in?
If you think about something like presumptive drug tests, right, which are notoriously unreliable and like flipping a coin, and those are used every day to make arrests in drug cases. Now, typically, you're supposed to have a confirmation in a laboratory that the substance at issue is actually a controlled substance. But what happens is that you have an arrest, and these are often marginalized folks who cannot make bail and are compelled to plead guilty on the strength of a presumptive drug test. So that's a junk science that's used all day, every day.
And this is tests of substances that someone's found to possess?
Yes, so a pill being tested, there's many notorious examples of aspirin being, false positive for ecstasy or fentanyl or some of these other drugs. So there's that, right? And then if you think about, the National Academy of Sciences 2009 report, as far back as 2009, which was the landmark publication in forensic sciences in this country, still the center of the discussion around the use of unreliable evidence, found that only DNA evidence is capable of identifying the source of crime scene evidence. Only, right? And yet, every day, right now, there's somebody testifying in some courtroom somewhere that bullet was fired by that gun to the exclusion of every other gun ever manufactured in the history of time, right? So we know that there is no statistical foundation for that testimony. That's been pointed out more than a decade ago, and yet it's still being admissible today. So there are things that are coming online, new technology like shot spatter, that's very, notoriously unreliable as far as false positives go. And now it's becoming used as direct evidence in courts rather than just a signal to alert the police to go to a particular location. Prosecutors are now trying to introduce it as direct evidence. Things like cadaver dog and other types of dog sniff evidence, which has been hyped like in this way that it's perceived to be infallible. Or dogs perceived to be infallible. And there's blood spatter evidence that's still being used today, right? And there's unreliable fingerprint evidence where we don't know how much information that we really need from a latent print. So this is not to say that fingerprints aren't unique or that it's not, or that it's junk science, but you can take a reliable technique and make it unreliable if you're trying to glean too much information when you don't have enough information to make a match, a so-called match. So the problem with junk science is very, very widespread in capital sentencing. About future dangerousness is often very speculative. So the lack of scientific rigor is pervasive, and with new technology being used all the time, and our faith as a society in this technology, it's really chilling.
It takes a lot of failures at various points in the system for junk science to have proliferated as wide as it has. Once a forensic scientist has invented some new technique, law enforcement has to call them up to have them, look at evidence. Prosecutors have to decide that their testimony is good and then offer it. Judges have to let it in. Judges reviewing convictions have to allow it to continue to serve as the basis of a conviction. I'm curious if that sort of cascade of failures should tell us something about the system as a whole, or if it's an isolated aberration from a system that's otherwise pretty good at the fact-finding piece.
Well, it's certainly not an aberration. And what we have, once you've identified a suspect in any criminal investigation, it's very, very hard from that point forward to ever get out of the criminal legal system. Is that a case gets developed, target gets painted around a bullseye, and and prosecutors are ethically required to believe in the guilt of the person that they're prosecuting, right? And so once somebody is persuaded that their suspect is guilty beyond a reasonable doubt, all of the tools that can be used to bring this person to justice are going to be deployed, and anything admissible is going to be used in service of convicting what the law enforcement believes is an obviously guilty person. And so that's really where the force is at play, right? Isn't like people aren't, judges aren't, prosecutors aren't, defense attorneys aren't thinking about systemic issues when they're talking about a case. So if you think about something that I map in the book is the first bite mark case. And you can see in that decision, which is very, very unusual to be able to find the first case, right? But you can see it in bite marks that what the judge found in that case, never been used in court before, no precedent for it, no science for it, no scholarship for it, no fundamental testing, it was just an idea. But what you see is that the judge, and this is a prosecution of a guy named Walter Marks, and Walter Marks appeared to have murdered his landlord. There was circumstantial evidence that suggested that, but they didn't have any hard evidence. And so what this prosecutor decided was that there was a bite mark on this poor woman's nose, right, that had been almost bitten completely off. And you could see, any one of us could see, that it was likely been made by teeth, right, which is not usual in like these injuries you get on skin that look like anything, right? And the judge decided that he was going to allow these forensic dentists, who were suddenly calling themselves forensic odontologists, to give this testimony because he could see with his own eyes that this was a match, right? And that there wasn't any whiz-bang technology, it wasn't black box technology or anything like that. It wasn't going to confuse the jury. And this wasn't even really science evidence, and he acknowledged that there hadn't been any scientific research, but because it was so straightforward, he was going to admit this evidence. And that became the germinal case. It spread like a virus around the justice system, and you can see how the first case just gets morphed into, suddenly it becomes scientific evidence. None of these courts are actually testing, you're not even getting Frye or Daubert hearings on the admissibility, they're pointing to precedent, right? And that's what judges look to when they're deciding admissibility issues. They're not consulting the literature. They're consulting legal precedent, right? And legal precedent doesn't move forward, right? Science is a process always moving forward. When hypotheses are falsified, they're abandoned, we move on to the next, we do more research, we learn more, it's always moving forward. So that's exactly the opposite of the way the law works, and that tension has led to wrongful convictions, and it also creates disincentives for the forensic techniques that we know not to be as reliable as they're claimed to actually do research on them, because they're already being used in the only place where it has any application. You don't need a ballistics expert in everyday life, right? So, and it's already being admitted in court, the only place where it's useful. Why do the research?
Mm-hmm. So another set of problems besides just the initial conviction, wrongful conviction of people with junk science, is issues having to do with post-conviction reviews. So someone gets convicted, and then they have these appeals and other motions they can file to try and prove their innocence and get themselves exonerated and released. The first problem is that you'll often have prosecutors continuing to defend cases even after the science has been debunked, and even after someone is quite obviously innocent but is still being held. And as I'm reading the book, the question that comes up over and over for me is, why do they do this? Why does the state continue to defend these bad convictions in these kinds of circumstances? So can you talk about some of the factors that probably go into that kind of decision?
I mean, there's so many disincentives to overturning a conviction, you know, I mean, and virtually all incentives are towards maintaining the status quo of any conviction. So there are a number of reasons, and one of the things that I find most unfair about post-conviction litigation, as somebody that does a fair amount, is that the convictions, say it's a bite mark conviction or a hair microscopy or an arson or something else, you know, I mean, that has been largely discredited, right? That we know that this evidence isn't very reliable. Is that that case, when you go and take it back and you want to demonstrate to the court that it's been convicted on unreliable evidence, that case is reviewed by, assuming that they're still in office, the same prosecutor who presided over their conviction and the same judge who sentenced your client to often life in prison for this crime. So you're asking somebody who had a subjective belief in the absolute guilt of somebody, whose most of these district attorneys are elected, right? And so there are political considerations about, you know, wrongful convictions are bad politics. And there's liability issues, not for the prosecutor because of the problem of qualified immunity, but sometimes civil and sometimes police officers are responsible for these. And then there is, you know, this confirmation bias that we all have, and that we as human beings tend to take in new information to confirm our previously held beliefs, right? That's how the human mind works. And so to try to convince somebody that they may have been responsible for a gross miscarriage of justice like this is also another hurdle. And layered on top of all this is something I talk a lot about, is the principle of finality, right? And then our legal system is, depending on who you ask, rests on this principle, right? In that we have jury verdicts, you're entitled to a fair trial, but that's really all you're entitled to. You get one little appeal and then that's it. And you don't even have constitutional right to that. So you have constitutional rights to due process rights to a fair trial. And beyond that, really the idea has always been that that's it, right? That's the principle of finality, that the justice system needs it, that victims' families need it, that we all need finality, right? And that's what was so disruptive about the advent of forensic DNA, right? Is that we showed, not me, but before I was in law school when this was going on, but is that so many of the most commonly used evidence in criminal trials, right? Eyewitness identification, confession evidence, and forensics were totally unreliable and had led to wrongful convictions, which should have been more disruptive to the status quo. And you know, one of the things that I write about, and this is why, is because how little changed as a result. You know, I mean, and so you factor in all of these different variables, and then what you end up with was what scholars and other people have called the unindicted co-ejaculator theories, right? So it's a play on the Watergate, right? The unindicted co-conspirators, right? Is that when you get even really definitive DNA evidence, like another case that I write about in the book, the Keith Harward case, is that where you've got DNA evidence that excludes somebody entirely, but not only excludes them, but then identifies the actual perpetrator. Often, you get prosecutors still denying innocence and inventing an unindicted co-ejaculator, right? Or somebody who is like not named, who is never part of an investigation, but appears on the scene in somebody's imagination in post-conviction just to deny relief. Or even a new trial, right? To have a fair trial, one where it isn't based on junk science. So there are so many hurdles, and this is why, often what is very frustrating is this notion that a lot of people have is like, well, the Innocence Project will pick up a case, and we'll work it out, right? And that it's so rare, a wrongful conviction is so rare, meaning that crusading lawyers will pick up, these rare miscarriages of justice. But, we have 2.3 million people in various forms of incarceration in this country, right? And if you think about maybe, 1%, or maybe wrongfully convicted, which I think is conservative, we're talking about tens of thousands of people.
You kind of touched on this a little bit, but the other issue that features really prominently in the post-conviction process in your book is just how long it takes to get somebody out, even after, outside the courtroom. To anybody else, it seems it's quite obvious that someone is innocent. There's one hearing in Mr. Howard's case that you talk about, that it's a relatively simple evidentiary hearing where you're questioning this charlatan forensic dentist. But it ends up taking about 18 months to schedule both parts of that, get it done. And then it takes another year to get the actual ruling from the judge. There's just this odd lack of urgency given what, again, to folks on the outside looks like an innocent person sitting in jail waiting for a judge to get around to ruling on the case. What should we attribute these kinds of delays to? Is it just courts are slow, it's complicated litigation, or does it sort of reflect the priorities of the system at all?
There are a number. It really depends on the jurisdiction, often what you're talking about. What I would attribute it to, as far as Mississippi goes, is gross indifference, to the plight of a poor black man on death row in Parchman Prison Farm, right? Is that there was no real urgency ever about his case. It was 6 months before he saw his first lawyer in the case. He sat in jail while no investigation is going on, nothing is happening with his death row sentence, right? For 6 months, right? So there's indifference, and then, post-conviction litigation is often unusual, right? So you think about your typical court are dealing with new arrests, new trials, and because of mass incarceration, processing the volume that courts are dealing with, and under-resourced and understaffed and indifference, you just get processing bodies is what is typically going on in our legal system. And that's what the criminal legal system is good at, is processing bodies, right? It's not good at correcting mistakes. It's not good at providing fair trials. It's not good at sussing out junk science from real science, from good eyewitness identification from bad, from a real confession to a false confession. Those things are very hard to suss out. What we do is you just move people through the system and we get pleas and we move on, right? And so suddenly you bring a post-conviction litigation. Somebody's been in prison for 30 years, right? Maybe on death row. And you're pointing to all this evidence of innocence. It's like, It's like, oh, what are we gonna do with this, right? And we don't even have like a prosecutor that's supposed to like specifically to deal with post-conviction litigation. You don't have some office. You don't have experts in this area. You have some line prosecutor who's used to trying cases will suddenly be dealing with this. Or it's the prosecutor who originally tried the case and it lands back on his or her lap and say, oh God, who wants to deal with that? And often there's no time limits, right? There's no, there's nothing but somebody's conscience to like make things, or a judge to force things along. So as a result, this ends up taking, outrageous amounts of time often. And I'm always amazed when something moves faster than I think it will. Right?
So your book details how bite mark evidence specifically has been discredited in a lot of places, thanks to a Herculean effort by a lot of different institutions and a lot of different people, and aided by a lot of hard-won exonerations of innocent people. Did anyone, besides the defendants, pay a price for the use of this junk science, whether the prosecutors or the practitioners? Were there career sanctions or like civil lawsuits, criminal charges?
You know, the first way I'd want to answer that question is that, and I know most of the bite mark exonerees, you know what I mean, that are living today, and I know virtually all the dentists that were responsible for those wrongful convictions, and I know that not one has apologized to any of the innocent men and women that they had wrongfully convicted. And virtually none have been held accountable either by their own organizations, the forensic community. Many continue to testify today, even though they were responsible for wrongful convictions. The Lowell Levine is still a practicing forensic odontologist. Talk about one of his cases in this book. Dick Souveron, who testified in the Ted Bundy case, still, although Dick Souveron, to his credit, will and has recanted prior opinions that have led to wrongful convictions. And you know, there were 2 dentists that were successfully sued. I thought that was, you know, represented some progress. You know what I mean? But it's notoriously difficult to hold any bad actors accountable, even for the most outrageous injustices and gross Brady violations and other types of prosecutorial misconduct or police misconduct, largely as a result of qualified immunity. But you know, even like somebody like Michael West has never been successfully sued, as far as I'm aware, you know what I mean? And so there's
the dentist who put
Eddie
Mr. Howard away,
and
yeah.
Levon Brooks and Kennedy Brewer, you know what I mean? And you know, the last I heard, and really the most bitter irony is that he was a prison dentist, of all things. So no, there isn't a lot of accountability in our legal system generally, and in forensics in particular.
So where do things stand then on the use of forensic science today? You kind of alluded to where things stand, but are we building sort of this immune system to keep junk science out, or are we, you know, where we've been for a long time?
You know, I don't want to be too cynical. You know, I mean, my job is to try to create change. You know, I mean, and to bring more, you know, scientific rigor and integrity to our legal system. So I think that we are making some incremental progress. The 2009 National Academy of Sciences report continues to reverberate around the country, but you know, to be too optimistic would be Pollyannish, you know, because the reality is, you know, one of the most simple things that we could do in forensics, because all forensics and most science, you know, there's a certain amount of subjectivity, some much more than others, right? Something like hair and bite marks are 100% subjective. But, you know, so are fingerprints and so are firearms analysis. These are all techniques that are eyeballed, you know what I mean? And as a result of that subjectivity, you have bias, right? And I devote a chapter to bias, right? And bias is one of the most commonly understood, well-researched phenomena of human decision-making that there is. You know,
And it's not just science, it's everybody.
It's everybody.
It has some biases. Yeah.
Everything that you do, you know what I mean? There's some bias associated. Where you look for on the wall in the light switch, right? You know what I mean? That's your confirmation bias, because you've knew from previous experience where you were likely to find the light switch, right? So it's a useful part of, you know, the way that our human mind takes shortcuts. But in forensics, there's been many studies. Most of the most well-known ones are done by Dr. E.T.L. Dror that demonstrate the pernicious influence of cognitive bias. You know, and so, you know, famously what he did after, you know, there was a false positive on the bombing of a commuter train in Madrid, Spain in 2004. Mild-mannered lawyer in Portland named Brandon Mayfield was identified through a fingerprint match to the blast caps, or the bag that held the blast caps of that, right? He'd never been to Spain, right? You know, but he happened to be Muslim. He had converted and he had married an Egyptian national. He happened to have represented somebody that was once convicted of providing material aid to a terrorist organization, so they thought they had his mat. They were wrong. So that was really startling, right? Because this is fingerprints, not bite marks. You know, I mean, even though both are totally admissible and used all the time, but there was an understanding that the fingerprints are much more reliable. So E.T.L. Dror, after that, had conducted this study that he had taken this casework, exemplars and latent prints from crime scenes, and he got 5 fingerprint examiners, who are all very, very well qualified, all certified, all with lots of experience. I think one of them is from the FBI crime lab, and sent them this work. And what he didn't tell them was it was from their own prior casework. They'd already come to conclusions on these, whether there was a match or not on these prints. And the only thing they changed was contextual information that was provided, right? The suspect confessed, or there was witnesses, or something like that. And 3/5 of them changed their original opinions from when they had originally concluded, right? And so nothing had changed about the fingerprints, only their minds, right? And so that's the influence that we have, and this has been demonstrated in many other fields, not just fingerprints. And so when you talk about progress, and we could blind experts from irrelevant case information. If we really care just about getting science, objective science, particularly in a subjective field, right? If we really cared about getting it right, not having forensics serve as confirmation of a law enforcement's theory or a prosecutor's theory of guilt, and really just about what the evidence does or does not show, we would blind the experts from this type of information. But there's no effort made like that. It was a zero cost, really. You could do that. So, and something else that I often talk about is that, consumer products in the United States, right? Aspirin, toothpaste, right? We have like the FDA, you have to demonstrate that these products are safe for consumer consumption, right? For public safety reasons. And we have nothing like that in forensics, right? You can go straight to death row on a bite mark. There's no agency that has to pass on this, So if we had something like, if the National Institute of Standards and Technology are the most scientific of like the federal agencies, right? If they were tasked with doing the validation research, demonstrating validity and reliability of forensic techniques outside of the adversarial system, right? Where there's no bias, right? And there's no pressure for a conviction. We're just doing actual research. You could fix it, right? So fixes are available, and it just demonstrates that we don't really care.
I understand the federal rules of evidence were recently amended on this question of when you can qualify expert testimony to be admitted. Will that amendment help at all?
Well, it hasn't been amended yet.
Okay.
I mean, it's the Rules Committee has offered amendments, and that still needs to be approved by Congress. It's a good step. It's an important step in terms of alerting courts that the rule is not working as intended, because it's allowing in something like 0 error rates, right? Which we're still seeing. I litigated a case last month in Colorado, a handheld toolmark case, where the experts, contemporary experts, are claiming 0 error rates on a human decision, right, in a subjective field.
And what exactly is it that they're testifying to?
So in a handheld, this is astonishing testimony in that there is one mark, a stria, on a 2 millimeter piece of wire, that the stria itself, which is basically just a scratch mark, is 1/100th of an inch. And they're tools that were seized by our client, Jimmy Genrich, in the late 80s, early 90s. And it's a wire stripper, a knockoff wire stripper made in China, and claims that only that wire stripper could have made that 1/100th of an inch mark, to the exclusion of every other wire stripper ever manufactured in the history of time. That's a contemporary opinion that's being defended right now by the prosecution in Colorado, right? And so the federal rules, the proposed amendment, at least point to this kind of 0 error rate, and individualization as, extravagant claims. That this rule, as currently written and applied in courts, is not working to exclude obviously exaggerated testimony at best.
So if folks watching at home are concerned about this issue, as I hope they are at this point in the conversation, obviously they should buy your book and read it, but is there anything else they can do to get involved? And if they do, are there any other kinds of reforms? We've kind of talked about some, but any other kinds of reforms that they should be supporting?
Well, I think that, one, it's important to be skeptical and be a skeptical juror, serve on juries. And I think that for those who have science backgrounds, for the scientists at home, is to get involved in forensics. Often what I will do is go to universities and talk to research professors about the problem of junk science in our legal system, and talk about the claims that are made that are routinely accepted. And invariably, they're stunned by what is passing as scientific evidence. And so it's really important to involve mainstream scientists in forensics and in our criminal legal system, because it will only lead to more rigor, more accuracy, prevent wrongful convictions. And it's important also, just when you're voting, that not just forensics, but if you're interested in reforming our legal system, which, thankfully there are more and more people who are, is that this is part of that. Wrongful conviction is part of that. Having scientific rigor, these are not just one-offs, right? You're talking about widespread use of technology that has never been foundationally tested, right? And that system that's in place exists, and it exists that will, as it currently exists, won't go away without real public outcry about it.
Mm-hmm. All right, I think that's a good note to leave us on. Thank you so much for being with us today. And thank you to everybody at home joining us over your lunch hour. The book is Junk Science.